Well, good morning, everyone. I am Eric Gjede, Vice President of Public Policy at CBIA. Here to give you a legislative update, and there is a lot to talk about. But first, I just want to tell you, I'm really excited to be here today. As my sticker indicates, I do love HR quite a bit. You guys truly are some of the hardest working people in every business. And just think about how hard the legislature makes this for you. I mean, that was a great discussion on paid family medical leave. It was a law that passed 2 years ago, and we still have so many questions. I mean, this is really difficult stuff that you folks have to deal with every single day. So, I really appreciate all that you do. Being here, I've been basically speaking to nothing but legislators since the beginning of February. So the few minutes that I get to spend here with you today is a little bit of a return to sanity. So I certainly appreciate that opportunity. This is my, I think, 9th HR conference that I've spoken at. And I recognize a lot of faces. There's a lot of folks I don't recognize. So I just want to, there's two things that make this segment a little bit different than a lot of what you're going to hear for the rest of the day. Now, one, some of you have noticed, and I know that because I read your evaluations, that some of this gets to be a little opinionated here and there. But you need to know that, I mean, I am an advocate. I'm up at the legislature, and in fact, I'm not just any advocate. I'm your advocate if you are a CBIA member. And all of the opinions I've expressed today about different pieces of legislation that are pending are what I've heard from you folks. It's not how I feel, it's what I hear from all of you. So I want to make that very clear. And we get those opinions from a variety of sources. Our CBIA surveys, we have a Labor and Employment Law Council where we have attorneys and human resource professionals that meet on a once-a-month basis. We talk about compliance issues. We talk about legislative issues during the session. So if you're not part of that and you'd like to be, we would love to have you. So please just get in touch with me. We can throw you on there. So that's where a lot of what I have to advocate for at the Capitol, that's where all that information comes from. Now, the other is that I am going to be the only speaker that is here today that is going to tell you what could happen, not what has already happened. All right? Everything, if you don't like what I have to say or you don't like one of the bills that come up onto the screen here, there's my clicker. If you don't like one of the bills that are up on the screen, you think that's going to be a real problem for you, there's an opportunity to take action to stop this. Talk to your legislators. I know it seems difficult. You're not sure how to get started. You don't even know maybe who those legislators are. Come to CBIA, just give me a call. I can walk you through the entire process. I can give you things that you should be thinking about, how to do it, what talking points you should use. I could do all of that and help you all through that entire process. But again, you have the power to change any of these things if you reach out. And one phone call truly does make a huge difference. So with that, why don't we start getting into, here we go. So, as I mentioned, legislative session is in full swing. This is the short legislative session, began the first week of February, will end the first week of May. It's, as I said, short session, so while it's less time than the long session, which was last year, which goes from January to June, it doesn't mean there's any less work. There's the same number of bills, you just have a lot less time to do it in. As you can see from the timeline where we are, the Labor Committee where most of this legislation originates that we're going to be talking about, has finished up their public hearings at this point. They're starting to take what's called JF, Joint Favorable Action, on a lot of the bills. That means it comes out of the committee. It goes through a nonpartisan office process, and then that means after it gets through there, it's ready for either the House or the Senate to act on it first and then send it to the other chamber before it goes up to the governor. So, and then everything concludes again on May 4th of this year, sine die. This next slide is just a reference to the makeup of the General Assembly. It's actually a little bit dated. There were a couple vacancies. A couple legislators decided to retire a little bit early, but those elections to fill those seats actually occurred, I think it was last week. So we have a couple new legislators. But the Republicans got one and the Democrats got others. So they kind of split the open seats there. There's no commentary on this makeup. I'm just giving it to you for your reference. I think we should also, as we talk about these bills, sort of set the stage in terms of Connecticut's economic conditions. CBIA did a survey last year, and in addition to obviously supply chain issues impacting businesses in the state and their ability to grow, and inflation driving up costs right now, we found that 80% of respondents to that survey were struggling to both find and or retain workers. Further, we have only recovered about 75% of the jobs that we lost during the pandemic. And I say during the pandemic because we hadn't even recovered all of the jobs we had lost before the 2008-2009 recession. So we were already down before the pandemic, and again, so now we're even further down. I think the next slide is pretty stunning, really. We have 110,000 open jobs in the state of Connecticut, and to make matters worse, we have lost about 92,000 people from our workforce. In fact, of all the losses across the country, Connecticut makes up 1% of the population, yet we have 10% of the national job losses here in the state. So it's pretty, to me, that's pretty, I think that's pretty eye-opening. Obviously, because it's so difficult to find and retain workers, the biggest investments Connecticut businesses are making are in their workforce. And in fact, according to the Bureau of Labor Statistics, wages are up about 10% year over year in the state. And Connecticut again continues to be one of the safest workplaces Connecticut workplaces are the safest in the country. Excuse me. So, while to me, that data that we just talked about and the inability to find workers and the lack of recovery from not only the 2008-2009 recession, but the pandemic-related recession, it shows that we're kind of teetering on the edge of a crisis here in the state. And so you would think the legislature, their primary focus would be on workforce development. And there are some committees that are working very hard on that. But the Labor Committee, again, where most of this stuff is going to come from, they continue to push mandate after mandate on Connecticut businesses that are going to continue to make your jobs more and more difficult. Now, a nonpartisan legislative office came out with a study. They looked at all of the labor mandates that have been enacted since 2016. And they found 28 of them, and paid family medical leave that we just talked about, that was one of them. Now, I counted back on all of the pieces of legislation that I testified against, the stuff that didn't get voted on, didn't get passed into law, and I actually found that I dealt with about 150 of them over the course of the same period of time. So, again, if thank God so few of them were enacted, or we would be having even more difficulties trying to get through your day-to-day here. So, again, we're in a critical situation in this state, and the governor came out on his opening day of session address and talked about the fact that we have a once-in-a-generation opportunity in this state this year, and he's right. We made some smart fiscal policy choices a few years back that helped us financially, at least, to get through the pandemic in much better shape. Of course, a lot of the federal stimulus money certainly helped. We have some short-term budgetary surpluses. There are people who, instead of talking about tax increases as they have year after year after year, there's bipartisan talks about some business tax relief that might actually help you guys grow businesses in this state. We should be making it more affordable to come to Connecticut so we can get more workers here, and we should be making it more affordable to run your businesses. But unfortunately, you could see from the headlines that I have posted on this slide, that has not been the direction the committee has taken. So why don't we start getting into some of these bills? Why don't we start with the good stuff first? And There's one that I really like, this bill, this first one, criminal record consequences. So as some of you may know, Connecticut has more occupational license requirements than any other state in the country. In fact, there's 350 separate occupational licenses in our state statutes. And quite a few of them have this sort of blanket prohibition that if you have any sort of felony on your record, you can't obtain that specific occupational license, which I think is crazy, especially if your crime, your mistake, whatever you had happen in the past has absolutely nothing to do with the job you're seeking to obtain. So this bill right here lists a whole bunch of occupations and gets rid of that blanket prohibition unless the crime was directly related to that occupation. Now, that does not mean you can't run a criminal background check. That does not mean you can't have a conversation with the employee, talk about, hey, what happened here before you decide if they're the right person for you. This just says that they can't be denied that occupational license solely based on that reason. And again, it's a lot of different occupations in there: barber, hairdresser, funeral director, dietitian, social worker, art therapist, various construction trades, liquor store ownership. So I think this is really good policy, just given the amount of worker shortage we have in this state, that, you know, we need to look other places to find people who are perfectly capable of doing these jobs and, you know, help them re-enter society. So I think this is a really good bill. We have certainly supported it. And, you know, again, we've got to start looking for alternate ways to fill those job openings in our state. So more good stuff. You know, not a whole lot on this one. It really applies a lot more to the state workforce, not the private sector. It just requires you to add additional poster about resources for victims of violence. So again, no reason to oppose that. Obviously, we want to provide as much information to people who are going through this horrible circumstances. So nothing wrong there. All right, COVID experience rate. Now, I kind of just want to smack myself in the head when I read this, unfortunately, because this is a really legitimate issue that the Labor Committee managed to completely screw up the language, but I actually have a feeling they might be able to fix it a little bit. So, Public Act 21-5, let's talk about what that did. So that it had nothing to do with workers' compensation. What that had to do with unemployment compensation. And basically the goal of it was, because there were so many people that were laid off during the pandemic, they wanted to eliminate all of that counting against your unemployment experience rate. So the fix that they put in place was that they would just say, okay, we are not going to count any unemployment that occurred in 2020, and we are not going to count any unemployment that occurred in 2021. We are just going to count what you did, because obviously it's used your experience rate. If you're an established business, you look back at the last 3 years. So we are only going to count what you had in 2019, right? Problem solved. Except you might be one of those few businesses that have reached out to me and had said, hey, we had a ton of unemployment in 2019, and then we didn't lay off anybody in 2020 or 2021. So, big problem. Those people now have their unemployment experience rate based on a horrible year, despite the fact they only had one horrible year and then 3 or 2 really good years after that. That's a problem. They are going to temporarily have a huge unemployment tax increase. So, because it's, or maybe I shouldn't say that, my opinion is, because it is pro-employer, I don't think the committee put quite as much effort into developing the bill as they could have, given that it has the Workers' Compensation Commissioner, which has nothing to do with unemployment, doing a study, rather than the Labor Commissioner, who actually does have something to do with unemployment. So again, I think we're going to get it fixed. I think we'll get there and work on this bill. And then this is not a Labor Committee bill. This is an Appropriations Committee bill. This would provide an additional federal relief for that massive unemployment debt that we have because of what we just talked about. So, as most of you probably know, Our unemployment trust fund, even pre-pandemic, was only about halfway towards its solvency goal, and then you have about 1.2 million claims for unemployment in a very short period of time. So that thing got depleted pretty quick. So we had to make sure that everyone who had a legitimate unemployment benefit claim got their benefits. And so just like we did in the last recession, we took on a pretty significant loan from the federal government to make sure all those benefits got paid out. We were not the only state to do that, of course. There were 22 other states that did as well. And a lot of states, the majority of states, even those who didn't have to take a loan from the federal government, they used some of that federal stimulus money, whether it was the Coronavirus Protection Act or the American Recovery or whatever it is, the ARPA Act. A lot of states, the majority of states, the majority of the 50, use some of that fund to either directly cover unemployment costs or to help down or pay down that federal debt that was taken to make sure all of those benefits would be paid. And so Connecticut, again, was one of those. And thankfully, last year, because of CBIA lobbying and a lot of other groups as well, we were able to convince the legislature to give about $155 million towards that unemployment debt. And the business community since that time has also paid about $300 million. Now, the problem is we still have about $463 million left in the principal on that. And then, on top of that, you also have another $350 million in interest and credit reductions that you will all be paying for in the next few years. That's a big issue, and if you remember back to 2018 or 2008, 2009, that recession, remember you getting all those special assessments in August, and then every year having your state unemployment tax rate creep up a little bit. We're going to go through that same thing again unless this is taken care of. So thankfully, the legislature has been talking about this issue. So again, they put their money where their mouth was last year, and I think they're going to provide some additional funds this year. Is it going to wipe out the whole debt? Probably not, but certainly it would be great to get a little bit more help so we can avoid what we had to go through during the last downturn. So we're going to be spending a lot more time here. Now, I put this in here. I'm certainly no workers' compensation expert. My colleague John Blair, he actually covers these issues for CBIA, but this would essentially go back in time to the way the workers' compensation system used to be, where it covered mental injuries that did not have a corresponding physical injury, what is called a mental injury. So obviously, years ago, back in the early 90s, this was the case, and workers' comp rates were just skyrocketing across the country, and so a lot of states made the choice that they were no longer going to cover these mental injuries because, A, the cost, and they were really difficult to either prove or disprove. So again, this grand bargain took place between organized labor and the business community, and this change was made, but now there is an effort to revert back to that. So, it is unfortunate because workers' comp in the state of Connecticut is one of the few areas where we've really been getting it right for a long period of time. Workers' comp costs have gone down. I think it's now 6 years in a row in the state, and as a result, it is as a result of workplaces becoming safer and safer and safer. So it's a win-win for everyone here. So it would be a shame to see this go in place and undermine some of that. Another one, not going to do a whole lot. I think the explanation of the bill is pretty self-explanatory. It's pretty self-explanatory here. If you're a contractor and you hire a bunch of subcontractors and that subcontractor just absconds with all the money and doesn't pay any of their employees, you become on the hook for that, despite the fact that you did everything right. And so obviously I think that's a dangerous precedent to set. Because why should you be punished for something that you did not do on your own? And there's plenty of avenues for folks to go after people who haven't paid them correctly at the Department of Labor. Restrictive scheduling. We've been talking about this for a long time now. So this bill has taken any number of forms over the years, but it's basically always the same idea that in certain industries, because of the nature of the industry, employers can't post employee schedules as far as in advance as employees would like. And this bill, if enacted, would essentially impose financial penalties on those employers. And also, if there was any sort of change in that schedule, without 2 weeks' notice, you are responsible for some additional pay, whether it's 1.5 times or 2 times the pay. Unlike a lot of the past versions, this bill applies to businesses with far more employees than it has in the past. A lot of times I have testified on this bill in the past against it. This year I chose not to. I think employers of that size, you should be able to provide that much notice to employees. I know that maybe a blanket statement and some industries simply can't, but and I know the other argument, of course, is that, yeah, we just get this on the books at 500 employees, and then, 4 years from now, we'll be down to 2 employees, as we do with so many other A's. So, yeah, I'm very well aware of the slippery slope argument, but, you do have to feel very sympathetic. There are people out there who are trying to go to work every day, try to make the ends meet, and just have no ability to make appointments, no ability to know whether they could take on a second job. Again, I certainly sympathize here, and so that's kind of why I didn't decide to go in on this. But, again, if there are specific cases here that I can raise for you up at the legislature that they should be thinking about, I'm more than happy to do that. Please just let me know. All right, this is a new one that I haven't talked about in the past. I think the target here are those, online sort of online retailers, big box, retailers as well. And a lot of these folks use performance metrics, just to make sure that they are able to provide logistical predictions for their customers. And the accusation being made on the other side is that these performance metrics are basically being used to make sure that people can't go to the bathroom or that they have to skip their meal breaks and that type of thing. And, obviously that would be detrimental to any business if that was what was actually going on. Unreasonable work quotas, you're not just going to, you're not going to just disincentivize the good employee or the bad employees. You're also going to really hurt morale for the good employees too. And not to mention the fact, if you've got people working like that, not taking their breaks, not getting their meals in, you're going to have less safe work conditions, which obviously is going to result in higher workers' comp costs. You're going to have OSHA violations. But, of course, that's not the picture that's being painted regarding this bill up at the legislature. So I did put in some testimony in opposition to this. Obviously, a couple other things. It would allow employees to ask for some speed data at any given time. That obligation extends in perpetuity. So even if the employee doesn't work for you anymore, you would have to store this information. So there's a lot of problems with this bill. If this is something that impacts your industry, maybe take a closer look at it. Non-compete agreements. I know not everyone uses non-compete agreements, and obviously, I don't think that they belong in every industry. But they are important tools in many industries to help protect trade secrets, emerging technologies. And these agreements are already heavily restricted by the courts in terms of scope, their geography, their duration, etc. However, I think any restriction on these should not be based on wages alone. I think they should be targeted more at different industries. Now, if you said to me, if you are a franchise restaurant owner and you're using non-competes so that your workers don't go work at the other franchise restaurant that's owned by somebody else just down the street, I think that's crazy. But if you use minimum wage, especially at this multiple, you start to get into some job occupations and industries that where employees do have access to a lot of really important information or customer lists or trade secrets. So I don't think that, and especially if you're using the minimum wage nowadays, which is a moving target since it goes up every single year. So you could have someone who's doesn't fall under this bill 1 year or does fall under it 1 year and then not the next. I mean, it's just again, it's difficult to administer. So. And especially when these, under this bill, they become invalid when the employer ends the employment agreement. I mean, if anything, that's when you probably need these agreements the most. So again, just if you do use non-compete agreements, certainly something to keep in mind. Paid sick leave expansion. There's actually a number of bills that effort to expand Connecticut's paid sick leave laws. Connecticut was one of the first states in the country to enact a paid sick leave law. It seems like forever ago, since now the conversation for the past couple of years has been dominated by family medical leave rather than sick leave. And if you may remember, Connecticut's current paid sick leave law, it applies to businesses with 50 or more employees, as long as you're not a manufacturer. And further, it only applies to a set list of job classifications, which are collectively called service workers. Again, it's a long list of job classifications. And it allows them to accumulate up to 5 days of paid sick leave every single year and roll that over into the next year if needed. Again, you can never have more than 5, but that's the current law. Now, it was always promised at the time when this was being advocated for that this was going to help stop absenteeism in the workplace. It was going to help with business retention. And the data since then has shown that it has done nothing of the sort. In fact, even businesses that had a paid sick leave law in place before this law went into effect had increases in their costs of doing business to comply with this law, just because you had to make sure it was aligned with what passed in the statute. So this does away with any of those business restrictions. Basically, that 50 employee threshold does away with that. It's down to 1, I believe. 1. And it gets rid of the manufacturing exemption, all of that, and it requires everyone to do it. It also requires you to provide 80 hours of COVID-19 paid sick leave for essential workers, which can be used retroactively. So if they had already taken time because of COVID, they can now go back and say, I want to be paid for that time. Just will add to the difficulty of keeping folks coming into your workforce, and it makes it even more difficult to abide by any scheduling restrictions that might be put into place, like we just talked about in the last couple slides. So this next one, something that I'm really concerned about, and it gets a little legal, but I think it's worth talking about, even though this may be a little outside of the scope of our day-to-day jobs here. So this is an attempt to put in place a law that is in California, and California is the only state that has this. It's called the Private Attorney General Act. For short, it's called PAGA. That's how we all call it. And what it does is it allows relators, which are either a nonprofit or a union, to go in, and a lot of employers, they have agreements with their employees, like, hey, if there's any dispute related to our employment situation here, let's just go to arbitration, which of course is easier for everyone. It doesn't require a law degree to get through it. It's a better and quicker way to sort through a lot of disputes. This says, okay, so the employee is subject to that arbitration agreement, but these groups can say, okay, well, we are going to bring a lawsuit on their behalf. And not only that, but it also puts in place what is called stacking penalty provisions. So it basically says, look, if under the statute there isn't a penalty for any sort of labor violation, we are going to put a $100 penalty in place for that. And not only that, but that $100 penalty is for every single pay period. So you're going to see why these type of lawsuits have increased 2,000% in California in just a couple years. So an example of how that might happen. So California business, it had a small typo in the business address on their pay stubs, okay? And an aggrieved employee, for whatever reason, went to see a lawyer. And the lawyer said, hey, okay, let me see your pay stub. And he's looking at it. He notices there's again, that typo related to the business address. Now, if you aggregate the number of violations there, so $100 every employee, every pay period over multiple years, they quickly found themselves in, with a potential millions of dollars of civil liability for that. And nobody is safe from this type of lawsuit. Some of the other victims in California include the AIDS Foundation, the Children's Home of Los Angeles, the Humane Society, and thousands of small businesses. And then to make matters worse, the aggrieved employees, they don't even get all the money that's collected here. 75% of the cases that were looked at using this law were found that the aggrieved employees were actually never made whole because the state gets a big chunk of the money and the relator gets the other big chunk of the money. So, again, very dangerous. I know it's probably a bill that belongs in the Judiciary Committee a little bit more, and that's probably why I think it's not the biggest threat on here. But if this ever does gain momentum, this is a serious issue for the state of Connecticut. Expanded pandemic layoff recall. So this slide's a little bit of a word salad, but the basics is that, and we've talked about this at past HR conferences, that if you employ either directly or through a third party any of people providing these services in your workplace, this may apply to you. You have to, if they were laid off during the pandemic, and you have to notify these individuals by not just mail, but also by text, if you have their phone number, of not just their job, if their old job, if it becomes available, but any job that they might be qualified for. And you have to then hire them back in order of seniority. So again, you look through all the former employees that might be able to perform this job or could be trained to perform that job, and you say, okay, this is the most senior one. I got to make a job offer to him. And they get 5 days to either accept or reject, and then you go down the next one. They have 5 days to either accept or reject. You keep going down. So obviously, that is a huge burden on any business who is just trying to find basically, for many of us, just find anyone who will, any warm body to perform some of our jobs. And if you don't, you could have a civil lawsuit brought against you. And that's exactly what they're doing with this. So, this bill passed last legislative session in June, at the very end of the legislative session. In fact, the last day of the legislative session and the last 4 hours of the legislative session. And it went into effect immediately. And there was zero outreach by any legislator, by any state agency to try to inform businesses of these new obligations, because that was never the intent. You were never supposed to comply with this law. This was simply an ability to provide standing for certain groups to bring lawsuits where organizing efforts had not been successful in the past. And we've seen a number of lawsuits on franchise businesses along the Merritt Parkway here in order to, using this exact law. And they would like to extend that out for another year. So obviously something that is concerning. Try to move through this quick. I know I'm coming a little short on time here, and we've got a couple more to go through. So this is the one that I believe you should be most concerned about this year as employers in the state. This is organized labor's number one ask. We are going into an election year, and obviously a lot of legislators are going to want their help with their campaigns. And they really want this bill. This would allow employees to simply get up and walk out of any meeting where they subjectively believe that the employer was talking about political matters. And the problem here, as you can see, is political matters are defined so broadly that it could mean virtually anything at all. Not just elections or politicians, which probably shouldn't be having those conversations in the workplace anyway, but legislation and regulations that directly impact your business, whether you get involved in civic or community events, all of those things. So, it could be anything. And again, I know A lot of you are probably thinking to yourself, well, this isn't really that big of a deal. We don't talk about politics in our workplace. But again, everything becomes political. In every one of you, I'm sure, has at least that one employee that likes to stir it up and say, oh, we don't have to go there. We could just get up and leave if we want. So this is just going to arm them with that ability to get out and threaten you anytime that you say something that they don't want to hear. And just think about all of the things this could apply to. I mean, everything's political these days, right? So, you want to talk about an energy conservation initiative within your workplace. Well, that's that global warming stuff that we don't want to talk about. That's political. We don't have to listen to this. We think it's really important to put in a DEI program, in our workplace, talk about issues like that. Well, hey, that's that critical race theory stuff that I hear so much about. We can't talk about that type of stuff. I want to talk about, we need to talk about the importance of our vaccine or our mask mandate policies. We don't want to listen to that. I'll choose what's right for my body. This is the type of thing that you're going to hear every time you try to have a serious discussion about serious, important issues in your workplace. So, you couldn't even talk about under this law, theoretically, whether you want to support the local Little League team. I mean, it is everything. So, again, I think it's going to be incredibly disruptive. I think it's preempted by federal law as well, but I am really concerned that this is going to have the momentum this year to pass into law. And I just want to touch on that preemption issue a little bit, and this is for my own sanity, probably less for you. So policy arguments aside, this bill has been around. I've talked about it at programs like this in the past. In fact, in 2011, this was the subject of an 11-hour debate in the House of Representatives. It finally passed through, and then Attorney General George Jepsen at the time came out and said, no, this is preempted by federal law. And it was an informal memo. They did it again in 2018, and he did the same thing, except this time he formalized it, put it in a actual legal opinion from his office, and that is that first column you see. That language right there, and this is only a 2.5-page bill. There's not a lot of other language to it. All of that language that you see right there, preempted by federal law, according to A.G. Jepsen. So, this year and a couple years ago too, committee decides to take that same language, just move it around a little bit within the paragraphs, and now all of a sudden they think, hey, we got around all our preemption issues, no big deal here, we're going to do this. And they managed to get the Attorney General, Tong, now, to say that it is probably not preempted anymore. But as you can see here, the words are exactly the same. They're just moved around a little bit, and the effect is exactly the same. They're just reoriented a little bit. So again, just for my sanity's sake, probably not something you care that much about in terms of the preemption issue, but again, it's how we're trying to address this issue up at the Capitol. And then this will be the final one that I touch on today, unemployment for striking workers. So under current law, if you are a worker that's impacted by a strike, and you can collect unemployment as long as you are not striking yourself, you're not interested in strike or supporting it in some way. It's like if they're just preventing you from getting to your workplace, you have nothing to do with it. Obviously, you can collect unemployment because you've lost your job through no fault of your own. That's not the case for people who are directly either involved in the strike or supporting it, and this would change that. So that you could collect while on strike after 2 weeks. To me, this is nothing more than giving additional leverage to the striking worker in labor negotiations, and also, putting additional financial penalties on you for prolonging the strike in terms of what's going to happen to your unemployment experience rates as a result of having to pay unemployment for people out on strike. So, just another bill. I think if you just look at these all collectively, everything that I've talked about today, it's troubling to me, and maybe it's troubling to you as well. There seems to be a pattern here where they think that businesses are, you guys are are just out to victimize your employees, and that you don't value them and all that they provide to your business. And just there's every effort to stack the deck against you all being able to perform your jobs. And I just think that's very troubling, especially given the economic conditions we are currently in today. So I did include here, and I'm not going to touch on them, a couple others just because they are out there, and these are, I just want to give you every bill in case you were curious that directly impacts the private sector versus, I didn't include any that have no impact on the private sector. But moreover, I just want to thank you all for your time today. I love this opportunity to come spend a few minutes talking about what's going on at the state capitol. I hope you found this information helpful, obviously. And, again, I just remind you all that none of this is set in stone right now. Please, if something has troubled you about what I've said, take action. I'm here to help you do that. You are the voices of Connecticut businesses, and lawmakers need to hear that voice. So with that, thank you all so much for your time. So.
Does anybody have any questions for Eric?
I know it's like lunchtime, so they probably don't, but I think there's one over there.
On the non-compete, what do you think is the likelihood of that getting passed?
I'm concerned about that one a little bit. The reason being is that the governor's office is the one that's really behind this. For whatever reason, this is a pet project of theirs. I do think there may be some opportunity to make the bill a little bit better, or maybe stop it outright. They've got a lot, obviously, on their plate. It's a very short session, not quite as many session days, of course, as the long legislative session. So, you're sort of asking me a crystal ball question, but I would say of all of the ones I've talked about, that bill and the captive audience bill are probably in my top 3 or 4.
Eric, we have a question over here to your left.
So what is the CBIA stance on taking off Social Security numbers from initial applications? And does that have reference to removing the ban the box effort that was done several years ago, or is this more on personal identity security for employees?
It's more that issue. We didn't take a position on it. I'm not sure most initial employment applications probably even request Social Security numbers anymore. The part that's a little bit annoying about the bill is that it makes it a discriminatory, rather than just like, you very easily could have just said, don't have that on your employment application, right? But instead they make it a discriminatory act, as if employers are, trying to discriminate people by trying to get their identity. It's just, the way it's drafted is just kind of like a kick in the face. But we did not take a position on it because, again, most employers are not impacted by that.
Hold on
Can't
one
see
sec.
anymore. I can see that hand, though.
Just clarification on the captive audience. It said that employees are allowed to walk out, which I understand, but does that mean we can still have the conversations?
That's correct. You can have the conversation, but you can't do it without the threat of someone just getting up,
Okay.
walking out at any given time. Yes.
It's like when you have a union campaign, you obviously want to, get your employees together to discuss, the pros and cons of that, or what have you. So you're still going to be allowed to have that. Just if they walk out, they walk out.
That's correct.
Okay.
And that's really, that's obviously the target of this bill, but they need it to be broader than that to survive that preemption challenge. I can't see, is that?
Anybody else? Eric, can you just tell us, I know you touched on this when you started, in your mind, what is the most important thing they can do, either these guys or the owners of the businesses? What can they do to help your lobbying efforts?
Yeah, the simplest thing is just to make a call. Legislators, I know we're a fast-paced digital world, and it's so easy to just fire off that email and check it off check the box. But they get they get hundreds of emails every single day. What they don't get are phone calls. And even if it's just leaving a message with their legislative aid, you can go right to the General Assembly website, or you can go to CBIA's website. You find out who your lawmakers are. We'll give you all that contact information. You just call and say, hey, I'm so-and-so. I'd like to talk to you about an issue, or just leave the message with the aide. They get really scared when they get phone calls because they get them so infrequently. So old school communication sometimes truly is still the most effective way of getting your message across. And again, you just say, this will impact me in this way. This is going to make my life a lot more difficult. Really wish that you would not support this or support this thing, whatever your opinion may be of the particular piece of legislation.
Did you have a question?
With the Section 3 law, with the Section 3 and general contractors, we've had to deal with that a little bit where our Section 3 did not pay his employees. And then we were contacted by a state marshal. So we're able to take the wages from his AIA payments. Is that something that's going to happen, or we're just going to have to pay their wages?
I think under this, you'll just be potentially directly responsible for those wages.
Okay, Eric, thanks very much.
Got it. Thank you.